My name is Jeremy Lusk, and I'm an attorney that practices in workers' compensation. And oftentimes we get questions when an injured worker is hurt as to whether there's some sort of penalty or an increased amount that the employer should pay due to the injury. There is a provision in the labor code. It's called a serious and willful petition that can be filed by the injured worker. It generally requires a few steps, and it's not frequently seen. It requires that the actions taken by the employer were willful. The employer intentionally did something or intentionally did not do something. If you're looking at the situation saying the employer should have known or the employer should have done something different or a reasonable employer would have done something different, that likely doesn't rise to the level of a serious and willful petition. Secondly, it needs to result in a serious injury. If it's a relatively minor injury, that doesn't usually qualify for the petition either. If a serious and willful injury is shown, then there is an increase of 50% of compensation to the injured worker. Just as a side note, one other way to show a serious and willful injury is by a violation of a safety order, violation of an OSHA order. In those situations, the injured worker would need to show that the employer violated the safety order and that the violation was a cause of the injury. There's a lot of permutations that follow with a serious and willful petition. So if you have further questions, feel free to send us an email or give us a call. We'd love to hear from you.